Good morning. This is your Kelso Report for Thursday, February 16th, and I'm your host, Clark Kelso. Today we have cases in the areas of revenue and taxation, health law, professional responsibility, juvenile law, and the Peace Officers' Bill of Rights. We begin with the Ninth Circuit in a revenue and taxation case. Marshall Naifi was about to cash in on his prior investment in a telecommunications company that AT&T wanted to buy. He stood to receive a $660 million capital gain on the purchase. In an effort to avoid California taxes, he incorporated a company in Nevada, transferred his notes in the telecommunications company into that company, and then executed the sale to AT&T. A year later, he passed away. The question for California's Franchise Tax Board was whether the gain was actually taxable under California law. Naturally, the FTB took the position that that transfer was an ineffective attempt to avoid California taxes. For the IRS, the question then became whether the estate could deduct from its assets the potential liability it had to the FTB. The estate claimed it was entitled to a $62 million deduction, because that's what it would have to pay the FTB if it turned out the transfer was ineffective. Ultimately, after several years of negotiation, the FTB settled for a mere $26 million. Well, the district court held that the estate could deduct only the $26 million, and it would not be permitted to deduct the $62 million estimated tax bill. Under applicable Treasury regulations, according to the court, that estimate was not reasonably certain. Instead, it was contingent and vague, and the amount of the possible liability ranged from 0 to $62 million. The Ninth Circuit affirmed the district court's conclusion in Richard Naifi Revocable Trust v. United States, and the estate's complaint for a refund was dismissed. But they get an A for effort. Now we have two health law cases from the California Court of Appeals. First, as part of the state's effort to protect physicians from overreaching by malpractice plaintiffs, Section 425.13 was added to the Code of Civil Procedure in 1987. It provides that, quote, in any action for damages arising out of the professional negligence of a healthcare provider, no claim for punitive damages shall be included in a complaint or other pleading unless the court enters an order allowing an amended pleading that includes a claim for punitive damages to be filed, close quote. In other words, the Superior Court pre-screens punitive damage claims. In Kaiser Foundation Health Plan versus Superior Court, the 4th District confronted a complaint against the Kaiser Foundation Health Plan and two Kaiser healthcare providers, alleging that the defendants had devised an insurance compensation scheme that induced Kaiser's physicians to deny costly medical services to plan members. The complaint initially sought punitive damages against both the service plan and the two providers. The defendants filed a motion to dismiss the punitive damage claims because of non-compliance with Section 425.13. By the time the case reached the appellate court, the plaintiffs had dropped the punitive damage claim against the two providers, and the only remaining question was whether Section 425.13 applied to the service plan itself. The language of Section 425.13 referred to any action for damages, quote, arising out of the professional negligence of a healthcare provider, close quote. So Kaiser argued it was entitled to the protections of the statute. After all, the case was about a doctor's refusal to refer someone for expensive treatment. Sounds like a malpractice claim. But when the court examined the legislative drafting history, it was clear that a predecessor version was intended to apply only to healthcare providers and not the service plan, and that a drafting change was made to accommodate a consolidation of statutory language at the very last second, without intending any change in meaning. So, the court interpreted the section as though it read, quote, in any action for damages against a healthcare provider, arising out of the professional negligence of that healthcare provider, close quote. At the end of the day, the punitive damage allegation against Kaiser is going to remain in the case and not subject to 425.13. Next, 2 pedestrians were critically injured when they were struck by a car whose driver suffered an epileptic seizure and lost consciousness. The pedestrians filed a complaint against the driver's neurologist and the neurologist's employer, University of Southern California, alleging that the neurologist had negligently concluded that the driver's epilepsy, because of special treatment he was under, did not affect his ability to drive safely. And the neurologist had communicated that conclusion to the Department of Motor Vehicles, which was investigating whether to reissue a license to the driver, notwithstanding several prior license suspensions because of post-seizure car accidents. In Wang v. Heck, the 2nd District affirmed summary judgment granted in the defendant's favor on the grounds that the communication to DMV was absolutely privileged pursuant to the litigation privilege in Section 47B of the Civil Code. As the court explained, litigation privilege does not apply only to trial court proceedings. Instead, it applies broadly to all kinds of truth-seeking proceedings, including administrative, legislative, and other official proceedings. In this case, according to the court, DMV was engaged in the process of trying to determine whether to reissue the driver's license, and the neurologist's communication to DMV therefore fell within the scope of the Section 47B protection. Next, a professional responsibility issue. A retainer agreement between a client and a law firm provided for binding arbitration of fee disputes. The parties participated in non-binding arbitration pursuant to the Mandatory Fee Arbitration Act. Then, within 30 days of a non-binding arbitration award that was issued in favor of the client, the law firm filed its demand for binding arbitration under the retainer agreement. The client responded with a petition to confirm the arbitration award. Well, the trial court sided with the client and confirmed the award, holding that the law firm's demand for binding arbitration was ineffective in the absence of actually filing a Superior Court action to compel arbitration. In Greenberg, Glusker, Fields, Clamon, and Machtinger versus Rosenson, the 2nd District disagreed and reversed the Superior Court, holding that the arbitration demand, standing alone, was effective to invoke the arbitration clause, without the formality of filing a Superior Court action to compel arbitration. The Mandatory Fee Arbitration Act provides itself that a non-binding arbitration award becomes final 30 days after the award, only if neither party commences an, quote, action or other proceeding, close quote. The 2nd District held that a demand for mandatory arbitration under the retainer agreement constitutes an other proceeding, and that the demand commenced that proceeding. That kept the non-binding arbitration award from becoming final, and then there was no need for a further filing to compel arbitration. Our next case is a juvenile law matter. In In Re KP, the 2nd District affirmed the juvenile court's decision to terminate parental rights in favor of adoption in light of the parents' continued drug use, the presence of firearms at the home, the father's incarceration, and the mother's failure to demonstrate a strong bond with the child. The mother argued that the parent-child relationship exception to the statutory preference for adoption applied, but the reports from the Department of Children and Family Services did not support her assertion that there was a strong child-parent bond. I'm sure it's just coincidental, but we've had a series of these cases this week, all of which involve drug use, incarceration, presence of weapons at home, and in every one of them, the courts are deciding these are appropriate cases to terminate parental rights and move towards adoption. Seems to be a pretty consistent result. Finally, a government law case arising under the Peace Officer Bill of Rights. The Peace Officer Bill of Rights gives peace officers a right of access to their personnel and internal affairs files. But in Barber v. CDCR, the 4th District held that this right of access exists only so long as the peace officer remains employed by the agency. According to the court, an ex-employee no longer has a right under Section 3306.5 of the Peace Officers Bill of Rights to review his or her records. That special right of access ends when the peace officer ends his or her employment with the agency. And that's it for today's Kelso Report. Have a great day in the law.